In 1956, Orlando Wines changed the way Australians drink wine with the first introduction of the Barossa Pearl brand of wine, a German-style sparkling wine, mostly marketed towards women. It was wildly successful. The bottles were not closed by the use of a cork and restraining wires in the way that champagne was closed. Instead, the bottles had a screw cap, and inside the neck of the bottle was a clear plastic stopper. It was designed to pop out spontaneously when the screw lid was removed. It was visible when the screw lid was removed, but it was not obvious until it popped out. The success of Barossa Pearl led to imitators, including Leo Buring's sparkling Rheingold wine, which used the same type of stopper. O'Dwyer purchased a bottle of sparkling Rheingold to open with his wife on New Year's Day 1963. Neither of them were habitual wine drinkers. He removed the screw top and tried to pour the wine, but nothing came out. The cap had not popped. He put it back on the table, but as he did so, the cap blew out, striking him in the eye and destroying the sight in that eye permanently. Was the seller liable in negligence? Justice Hale said, "Any bottle of wine will be opened by hand, and the neck of the bottle will be within about 18 inches of the operator's face and may well be closer. The defendant marketed an article which behaved in the way it was intended to behave. In doing so, it was, in my opinion, obviously capable of causing injury, and it did cause to the plaintiff the sort of injury that was to be foreseen." The manufacturer, however, argued that O'Dwyer had contributed to his own harm by not taking sufficient care. Justice Hale disagreed, saying he was handling something with no known vicious propensity in the peace of his own dining room, and the only duty of care to which he would be likely to advert would be the duty to avoid spilling the wine on his wife's luncheon table. And it is in this sort of atmosphere that the defendant must have contemplated that much of its wine would be consumed. From this case, we learn that a manufacturer whose product is inherently but not obviously dangerous will be liable for any harm caused unless sufficient notice of the danger is given.